Hello everyone. So today we are going to discuss very important concept, and that concept is mostly important for not given in your UPSC optional, but that is important in understanding the concept of law, right? Understanding or writing the answers, right? Because that argument is a very general argument that you can write in almost every doctrine that you have in your international law or constitutional law, right? So this is a understanding. Okay, so this is basically a foundation to understand your writing practice. Okay, so that is sort of an aiding instrument rather than the actual meaning, right? And it is only mainly for the purpose of UPSC. Okay, so keep that thing in mind. Okay, now see, two things that people generally who are not from law background and even from law background get confused. What is the meaning of common law versus civil law systems? Right? Because mostly you will find that this doctrine have a common law origin. So what do you mean by this? Okay, like if you have to write, you can write an argument sometime that okay, this particular method is not suitable for a common law state, right? Like India. Okay, so let us try to have a meaning. What do you mean by it, right? From the perspective of UPSC. See, common law primarily, if you think about it, is basically have been derived in England, right? And in England, what used to happen, that the king used to command, right? Then, now king command used to be called writs. So king used to perform justice. The second justice that was performed by the courts established by the king. So they used to be judges, right? Now, the ultimate law that was applied is good conscience and equity, right? Now that is a very subjective word. So what used to happen there, that judges used to decide some particular case based on their own wisdom, right? Now that wisdom started to be followed by next decision by the courts in that particular country, right? So that wisdom became doctrine, right? And this origin became common law. It means law which is common, right? That is coming from very old time. Understood? Now similarly in civil law, whatever the law or the wisdom has to be codified. It means there has to be a written law. However, later on this common law also we had codification, right? But primarily you will see that most of things are there that is basically based on some common law, okay? In spite of having some codification. Like for an example, let's say you must have seen this volenti non fit injuria. It is a common law doctrine. The codification is there in our criminal law as well. You must have seen in the criminal law, if you consent for taking some harm, then the harm doer is excused. Okay, so that is one of the manifestation of the common law doctrine. Understood? So that is the first primary difference. Okay, the origin. Right. Second primary difference is basically the structure in which the judicial system of that country functions. Right. Here, what we have, when a decision is made in the common law, now the ratio of that decision is generally binding. Okay. But in the case of civil law, when the decision is made, that decision only have a persuasive argument in the next court decision. It is not binding. Understood? Now there are various nuances attached to it, like in common law. If it is binding, then you must think that it will lead to less case. Why? Because if there is any case and there is a common law judgment, then by default by and large you can conclude that okay, this will be the judgment of the court, right? So the purpose was that the number of cases will reduce. You need not to go to the court, you simply look at the judgments and the decision will be there. So that is the first point. Now if you think about the second point, the second point that is in the for the purpose of this civil law doctrine is that when a law is written and its meaning is defined by the courts, right, it do not take into account changes that is happening in the society. So if the meaning of something is there refined in 1970 and the same thing you get binding in 2020, so that won't be a very good thing, right? So in the case of civil law, we have a persuasive value of that particular judgment. It means the court can take into account the recent changes, right? Here also they can take into account, but only the highest court, not in that lower level. Okay, so that is one of the utility of having a civil law, right? The practical example, if you look at the common law judgments, you will see courts having almost plethora of judgments they are citing, but in the civil law you won't find, multiple judgments are simply few pages, right? And here it is few hundred pages in the common law, right? So that is the second piece of difference. The third piece of difference, and that actually you can use for the purpose of writing ADR mechanism, right? The philosophical argument you can talk about, right? ADR is a product of a civil law system rather than a common law system, right? So those arguments you can make in writing your answers, right? So that is why I told you this particular lecture is for the purpose of enabling you writing law answers in UPSC, right? Rather than the topic itself, okay? That I find that most people are, very not good at knowing it. Now the third important point that you should keep in mind, that in the common law system, the judge and the lawyers are very much involved in the decision making process. Right? We did not have jury system, where jury system are the judge and lawyer basically dependent on jury, and it is very much involved, right? The judge controlled what questions will be put to jury, and the lawyer is very much personally involved in making the arguments and everything. In the civil law system, it is not there. Right? It is more of a people friendly. Anyone can draft a petition and go to courts, right? But in common law system, it is generally, a legislature. A statute which provides, okay, if you have this qualification, then you can only talk about going to courts, right? So it is more of a professional thing in the common law system, right? It is a profession, and here anyone can go it, right? So obviously there are relative merit and demerit attached to that system, right? But you can use that in writing answers. Suppose you are writing answers regarding the judicial activism, right? So judicial activism is basically infusing some of the civil law component in the common law system. Understood? Okay, so you understand this particular topic with respect to all other topic, right? So that it will help you in effectively writing answers. Understood? Now, generally speaking, which courts have these, right? So it is a very historical thing where the England ruled. They have common law system, like in India, in Canada, in United States, right? And where the Portuguese and the other ruled, right? They have a civil law system, right? Now, this was the traditional understanding. Now, there are certain instances where the common law is almost has becoming civil, right? Like law of tort. Tort basically depending on the common law system, but you don't find any tort cases in India currently, right? Very less amount, okay? So most of the things are now codified. Understood? Now this common law was basically result of the time when you don't used to have much paper, or don't used to have much things to write or print, right? So that is a very ancient type of system, right? It is a modern system if you can talk about. Now there have been argument whether India should shift to civil law system. So obviously it will require a huge effect, right? A huge changes. So obviously that is not feasible. So you have to adjust within the common law system also. Common law system itself, rather than replacing it with the civil law system. Okay. And if you have any further confusion, obviously you can comment, and I will definitely try to answer it. If you want to check other videos, you must be knowing how to see it. Thank you very much.